What's involved in getting a divorce really depends upon what the issues are. When a divorce is filed, it's a lawsuit. It's a lawsuit just like any other lawsuit, like a car crash or a contract action that's gone bad. Somebody files a lawsuit against the other. In a divorce, you just happen to file your lawsuit against either your husband or your wife. If you have children, if you have a situation where you have a large income disparity between the parties, you can ask for temporary orders to be put into place. But everything gets started with the filing of the lawsuit. That's called a complaint for dissolution of marriage or a complaint for legal separation. That is filed. The other side then has 30 days to answer that lawsuit once they are served. And they can either sign a paper that says they've been given the lawsuit and they acknowledge the jurisdiction of the court, or the sheriff will find them, put the papers in their hand, and then the court will assume jurisdiction over them. After that has been accomplished, that the party has been served, either by the sheriff or by signing the paper, one side can request the court to enter temporary orders. It will do so in terms of child custody, where is the child going to live until there can be a further hearing, or should dad or mom pay the other parent money for support or for alimony during the time of the divorce action. So that hearing can take place in 2 to 3 weeks' time after the divorce petition has been filed. It can be later, but generally in a 2 to 3 week time frame is what you're looking at. After the complaint for dissolution has been filed, there's a mandatory 60-day cooling off period put in place by our Nebraska statutes because the state as a whole does not want to encourage divorce. So you have this cooling off period that's built into the statutes that say that nothing further on the case is going to happen for 60 days after the complaint gets filed, other than that hearing on temporaries that we discussed before. After the 60 days has passed, then the parties can go ahead and ask the court for a trial. In reality, that never happens. What will happen is the complaint for dissolution will be filed. Sometime after that, 2, 3, 4 weeks later, a hearing is going to be held on temporary matters. That is a very important hearing, particularly if you're pursuing custody of the children, because that hearing decides where the children are going to live until there can be a trial. The divorce is just like a trial when you have your what's called a final hearing. That can be almost up to a year away. So where the kids are going to live for that year's period of time is very important, and we take that temporary hearing very, very seriously. It takes a lot of preparation time, and a lot of money is spent just getting ready for that very first hearing. That first hearing traditionally is held on affidavits only. You'll hear discussions from attorneys about getting ready for the temporary hearing by getting together letters, affidavits. Nobody goes to the temporary hearing but the attorneys. The attorneys go with the letters that their clients have been able to gather for them. Those letters are put into an affidavit form. They're sworn to under oath, and that's the information that the court is given, that the court will make its first decision on as far as where their kids are going to live, and I'm talking in terms of custody, but also how much money will be paid in alimony or child support, things of that nature. After that temporary hearing is held, then generally what you'll go into is called the discovery phase. In the discovery phase, both attorneys will send to the other written questions that the other parent has to answer under oath, such as, tell me every single reason why you think parent A should not have custody, parent A being your own client, because you want to know what arguments you're going to be facing. Tell me who your witnesses are going to be at our trial. Tell me what exhibits you're going to be showing to the court at our trial. You do all those things so that you can discover what the other side's case is all about so you can prepare to meet it. So you go through the discovery stage, and then after the discovery stage is over, you'll have another hearing with the court that's called a pretrial conference. At the pretrial conference, again, just the attorneys go, and they have a conference with the judge where they talk to the judge about how much court time do they think they're going to take, and then the court will generally give them about half as much time as they think they need. They talk about where they're at in terms of settlement discussions, how long they think the trial is going to take, how many witnesses they're going to have, what exhibits they're going to have for the court, and then the court will do a couple things. The court can order them into mediation so that they can try to resolve it before the court has to resolve it for them, and then the court can order you report back to me in 2 months' time after you've gone through mediation, tell me if you have an agreement or not. And the court will also set a trial date, which could be 2 or 3 or 4 months down the road in terms of when the trial is going to be. Then you're going to have what's called the final hearing. That's your trial. Just like Perry Mason, everybody comes to the trial. You'll have the gallery, where people who are waiting to testify or people who are there to watch will sit. I like to say it's like a wedding. When you go into a courtroom, almost always the courtroom is divided into 2 halves. You have a table where the parties and the attorneys sit on one side, and a table where the parties and the other attorney sits as well, and then there are rows of benches behind them. So it's just like as you walk into a wedding, it's either a friend of the bride or a friend of the groom, but traditionally you'll have all of mom's supporters sitting behind her and all of dad's supporters sitting behind him, and you go ahead and you have your trial at that point in time. After you have your trial, the court will either rule from the bench, where the court makes its decision and makes it known to the parties right there on the spot. That's almost never done. Or the court will take the matter under advisement. If the court takes the matter under advisement, then the court will take all the exhibits and all the testimony and go back into their office and will issue a decision, which can be 2 or 3 weeks later, can be 2 or 3 months later, depending on how busy the court's calendar is. But that's what's involved in a dissolution of marriage thumbnail sketch from start to finish. It can be a very involved process if the parties are fighting over issues of custody, visitation, parenting time, child support, alimony. All those things take time to discover. It can also be a very speedy process if the parties have generally come to terms with how they want things to go. I have had cases in my career that are done in 60 days. It doesn't happen very often, but it does happen. They can go from 60 days to 1.5 years, depending on the parties and what's at issue.